Hi, welcome back to my channel. So for today's video, we are going to discuss Article 3 of the Revised Penal Code using the same reference, the book of Judge Abudiente and Luis B. Reyes. So Article 3, definitions. Acts and omissions punishable by law are felonies or delitos. Felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. So there is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. So Article 3 basically is the first article under Title 1, Felonies and circumstances which affect criminal liability. So Article 3 defines what is felony. So again, felony is defined as those acts and omissions which are punishable by law. Now let us proceed to the elements of felony. So there are three elements of felony. So the first one, that there must be an act or omission. Number 2, that the act or omission must be punishable by Revised Penal Code. And number 3, that the act is performed or the omission incurred by means of dolo or culpa. So before we proceed on the detail of Article 3, let us first understand some of the important words and phrases under Article 3. So the first word we have is act. So the word act must be understood as any bodily movement tending to produce some effect in the external world, it being unnecessary that the same be actual produced as possibility of its production is sufficient. But the act must be one which is defined by Revised Penal Code as constituting a felony, or at least an overt act of the felony that is an external act which has direct connection with the felony intended to be committed. So, example of a felony by performing an act. So, A took the watch of B with intent to gain and without the consent of the latter. The act of taking the watch of B with intent to gain constitutes the crime of theft. So, only external act is punished. So, act must be external because internal acts are beyond the sphere of penal law. Hence, a criminal thought or a mere intention, no matter how immoral or improper it may be, will never constitute a felony. Thus, even if A entertains the idea of killing B, as long as he does not commence the commission of the crime directly by overt act, A is not criminally liable. So now let us proceed to the word. Omission. So by omission is meant inaction or the failure to perform a positive duty which is bound to do. So there must be a law requiring the doing or performance of an act. So these are the examples of felony by omission. So number 1, anyone who fails to render assistance to any person whom he finds in an uninhabited place wounded or in danger of dying is liable for abandonment of persons in danger. And number 2, an officer entrusted with collection of taxes who voluntarily fails to issue a receipt as provided by law is guilty of illegal exaction. And number 3, even person owing allegiance to the Philippines without being a foreigner and having knowledge of any conspiracy against the government who does not disclose and make known the same of the proper authority is liable for misprision of treason. So it will be noted that in felonies, by omission, there is a law requiring a certain act to be performed, and the person required to do the act fails to perform it. So the omission must be punishable by law, because there is no law that punishes a person who does not report to the authorities the commission of a crime which he witnessed. The omission to do so is not a felony. Now let us know the word punishable by law. So this is the other element of a felony. This is based upon the maxim of nullum crimen nulla poena sine lege. That is, there is no crime where there is no law punishing it. So the phrase punished by law should be understood to mean punished by the revised penal code, not by a special law. That is to say, the term felony means act and omission punished in the revised penal code, to distinguish it from the words crime and offense, which are applied to infractions of the law punished by special statutes. So, under this article, a person may have committed an act. It could have been committed by means of deceit. But if it is not punishable by law, or if there is no law punishing it, it could not be considered a felony. So, for example, Juan became so desperate that he wanted to end his life. So he got a rope and hung himself. However, his brother arrived timely and he was saved. So the question is, did Juan commit a felony? The answer is no, because there is no law punishing suicide. Supposing his brother aided Juan when the latter was committing suicide, is the brother liable? Yes, because there is a law punishing the act of giving assistance to suicide. Another example. So Juan wanted to end his life, so he went to the rooftop of a tall hotel and jumped. He, however, fell on an old woman who cushioned his fall. Juan was saved, but the woman died. Did Juan commit a felony? No. Although there was an act of committing suicide, the same is not punishable by law. Now let us proceed to the classification of felonies according to the means by which they are committed. So under Article 3, it classifies felonies according to the means by which they are committed. So number 1 is intentional felony, and the second one is the culpable felonies. So thus, the second paragraph of Article 3 states that felonies are committed not only by deceit or dolo, but also by means of fault or culpa. So let's go to intentional felonies and culpable felonies. So, unintentional felonies, the act or omission of the offender is malicious. So in the language of Article 3, the act is performed with deliberate intent, with malice. So the offender, in performing the act or in incurring the omission, has the intention to cause an injury to another. While in culpable felony, the act or omission of the offender is not malicious. So the injury caused by the offender to another person is unintentional, it being simply the incident of another act performed without malice. So as stated in Article 3, the wrongful act results from imprudence, negligence, lack of foresight, or lack of skills. Now let's go to felonies committed by means of dolo or with malice. So the word deceit in the second paragraph of Article 3 is not the proper translation of the word dolo. Doulos is equivalent to malice, which is the intent to do an injury to another. So when the offender, in performing an act or in incurring an omission, has the intention to do an injury to the person, property, or right of another, such offender acts with malice. If the act or omission is punished by the RPC, he is liable for intentional felony. So there are also crimes which cannot be committed through imprudence or negligence, such as murder, treason, robbery, and malicious mischief. Now let us proceed to felonies committed by means of fault or culpa. So between an act performed voluntarily and intentionally and another committed unconsciously and quite unintentional, there exists another performed without malice. So but at the same time punishable, though in a lesser degree and with an equal result, an intermediate act which the penal code qualifies as imprudence or negligence. So a person who caused an injury without intention to cause an evil may be held liable for culpable felonies. So let's take the case of U.S. versus Divino, 12 Phil 175-190. So the defendant, who was not a medical practitioner, tied a girl, wrapped her feet with rugs saturated with petroleum, and thereafter set them on fire, causing injuries. His defense was that he undertook to render medical assistance in good faith and to the best of his ability to cure her ulcer. It was held that while there was no intention to cause an evil but to provide a remedy, the defendant was liable for physical injuries through imprudence. Now let's go to imprudence, negligence, lack of foresight, or lack of skill. So imprudence indicates a deficiency of action, while negligence indicates a deficiency of perception. If a person fails to take the necessary precaution to avoid injury to person or damage to property, there is imprudence. If a person fails to pay proper attention to the due diligence in foreseeing the injury or damage impending to be caused, there is negligence. So negligence usually involves lack of foresight, while imprudence usually involves lack of skill. So now let us go to the reason for punishing acts of negligence or culpa. So a man must use common sense. So a man must use common sense and exercise due reflection in all his acts. It is his duty to be cautious, careful, and prudent. So if not from instinct, then through fear of incurring punishment. So he is responsible for such result as anyone might foresee, and for his acts which no one would have performed except through culpable abandon. Otherwise, his own person, rights, and property, and those of his fellow beings would ever be exposed to all manner of danger and injury. So, in felonies committed by means of dolo or with malice, and in felonies committed by means of fault or culpa, the acts or omissions are voluntary. So, an intentional felony is committed when the act is performed with deliberate intent, which must necessarily be voluntary. While on the other hand, inculpable felony, which is committed when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skills, the act is also voluntary. The only difference between intentional felonies and culpable felonies is that in the first, the offender acts with malice, whereas in the second, the offender acts without malice. So a criminal act is presumed to be voluntary. Fact prevails over assumptions. And in the absence of indubitable explanation, the act must be declared voluntary and punishable. Now let us go to the 3 reasons why the act or omission in felony must be voluntary. So in the revised penal code continues to be based on classical theory, according to which the basis of criminal liability is human free will. So the second one is acts or omission punished by law are always deemed voluntary since man is a rational being. One must prove that his case falls under Article 12 to show that his act or omission is not voluntary. So, Article 12 are those circumstances which exempt from criminal liability. Okay? And the third one is that in felonies, by dulo, the act is performed with deliberate intent which must necessarily be voluntary, and in felonies by culpa, the imprudence consists of voluntarily but without malice, doing or failing to do an act from which material injury results. Therefore, in felonies committed by means of dulo, as well as in those committed by means of culpa, the act performed or the omission incurred by the offender is voluntary. But the intent or malice in intentional felonies is replaced by imprudence, negligence, lack of foresight, or lack of skills in culpable felonies. And now let us proceed to the requisites of dulo or malice. So in order that an act or omission may be considered as having been performed or incurred with deliberate intent, the following requisites must concur. So number 1, he must have freedom. So freedom while doing an act or omitting to do an act. Number 2, he must have intelligence while doing the act or omitting to do the act. Number 3, he must have intent while doing the act or omitting to do the act. So number 1, let's talk about freedom. So when a person acts without freedom, he is no longer a human being but a tool. So his liability is as much as that of the knife that wounds, or of the torch that sets fire, or of the key that opens a door, or of a ladder that is placed against the wall of the house in committing robbery. Thus, a person who acts under compulsion of an irresistible force is exempt from criminal liability. This is under Article 12, Paragraph 5. So likewise, a person who acts under the impulse of an uncontrollable fear for an equal or greater injury is exempt from criminal liability. This is also from Article 12, Paragraph 6. Now let's go to intelligence. So without this power necessary to determine the morality of human acts, no crime can exist. Thus, the imbecile or the insane and the infant under 9 years of age, as well as the minor over 9 but less than 15 years old and acting without discernment, have no criminal liability because they act without intelligence. This is under Article 12, Paragraph 1, 2, and 3. Then the third one is intent. Intent to commit the act with malice, being purely a mental process, is presumed, and the presumption arises from the proof of the commission of an unlawful act. So all the 3 requisites of voluntariness in intentional felonies must be present because a voluntary act is a free, intelligent, and intentional act. So intent presupposes the exercise of freedom and the use of intelligence. So one who acts without freedom necessarily has no intent to do an injury to another. One who acts without intelligence has no such intent. But a person who acts with freedom and with intelligence may not have the intent to do an injury to another. Thus, a person who caused an injury by mere accident had freedom and intelligence. But since he had no fault or intention of causing it, he is not criminally liable. This is under Article 12, Paragraph 4 of the Revised Penal. So criminal intent is presumed from the commission of an unlawful act. So criminal intent and the will to commit a crime are always presumed to exist on the part of the person who executes an act which the law punishes unless the contrary shall appear. But the presumption of criminal intent does not arise from the proof of the commission of an act which is not unlawful. So there is no felony by dolo if there is no intent. So the presumption of the criminal intent from the commission of an unlawful act may be rebutted by proof of lack of such intent. Now let us proceed to felonies which are committed by means of fault or culpa. So there are also requisites which we must need to consider. So the first one is he must have freedom while doing an act or omitting to do an act. Number 2, he must have intelligence while doing the act or omitting to do the act. And the third one is that he is imprudent, negligence, or lack of foresight or skill while doing the act or omitting to do the act. So mistake in the identity of the intended victim is not reckless imprudence. So a deliberate intent to do an unlawful act is essentially inconsistent with the idea of reckless imprudence. Where such an unlawful act is willfully done, a mistake in the identity of the intended victim cannot be considered as reckless imprudence. So this is based on the case of People versus Gillen, 85 Field 307, citing People versus Nakel, 43 Field 232, and People versus Guea, 54 Field 605. So a person causing damage or injury to another without malice or fault is not criminally liable under the Revised Penal Code. Since felonies are committed either by means of deceit or dolo or by means of fault or culpa, if there is neither malice nor negligence on the part of the person causing damage or injury to another, he is not criminally liable under the Revised Penal Code. In such case, he is exempt from criminal liability because he causes an injury by mere accident, without fault or intention of causing it. Now let us go to the third class of crimes. So, there are 3 classes of crimes. So the Revised Penal Code defines and penalizes the first 2 classes of crime, which is the intentional felonies and the culpable felonies. So the third class of crimes are those defined and penalized by special laws, which include crimes punished by municipal and city ordinances. So dolo is not required in crimes punished by special laws. So when the crime is punished by a special law, as a rule, intent to commit the crime is not necessary. It is sufficient that the offender has the intent to perpetrate the act prohibited by the special law. So intent to commit the crime and intent to perpetrate the act must be distinguished. So a person may not have consciously intended to commit a crime, but he did intend to commit an act, and that act is by the very nature of things the crime itself. So in the first, intent to commit the crime, there must be a criminal intent. So the second, the intent to perpetrate the act. It is enough that the prohibited act is done freely and consciously. So the rule is that in acts mala inse, there must be a criminal intent. But in those mala prohibita, it is sufficient if the prohibited act was intentionally done. So the difference between mala inse, so I did a video about the difference between mala inse and mala prohibita. I will link it down in the description. And then now let us go to the reasons why criminal intent is necessary in crimes made such by statutory enactment. So when the doing of an act is prohibited by a special law, it is considered that the act is injurious to the public welfare, and the doing of the prohibited act is the crime itself. So good faith and absence of criminal intent are not valid defenses in crimes punished by special laws. So I think that ends the discussion in Article 3. So under this discussion, you also need to know the difference between mala inse and mala prohibita, which I will link it down in the description. And you also need to know the difference between intent and motive, which I will also link on the description. And also, I also make a video about mistake of fact, which is also important to understand under this article. So I think that ends my video, and thank you for watching. Bye bye.